Hi, this video is on criminal law responses to situations of intimate partner violence where the person who is a survivor of violence or a victim of violence has themselves reacted violently, either in self-defense or out of fear for their life. Again, here are resources for assistance if they would assist you, and live links are available on our website. So, under the criminal law, traditionally there were a couple of different options that were used in situations where people had acted out of self-defense or provocation. There are also some cases on the battered women's syndrome, which I'm not going to go into a lot of detail here because it's been overtaken by some amendments to the criminal code. For traditionally, self-defense was available for both provoked and unprovoked assaults, and if you use deadly force, it had to be only in response to deadly force. The issue with self-defense for many people who are survivors and victims of intimate partner violence is that the person had to act in self-defense at the time that the other person was actually offering violence to them. And many people who unfortunately use violence to escape from a violent situation themselves may harm their partner in a situation where the partner is incapacitated. So, as in the Keener case where the male partner was asleep, Robin Keener had killed him after a truly appalling history of physical violence, including appalling sexual violence to her and threats to her family to also use similar appalling violence against them. So that would not fit with self-defense. Another option for people who killed their violent partners or who harmed them was the issue of provocation. This can be used because of the Van den Hout case that said that fear could be sufficient to act as provocation in a situation where a person lost all self-control due to the extreme emotion of fear rather than of anger. For provocation under our criminal code, there's section 269, which is provocation for non-lethal force. It does not have limits around using violence against a partner who provokes the person. And section 304, killing on provocation. And in this one, there are limits on using the argument that there was provocation where the deceased had said or acted to end or change their relationship or indicated that they had an intention to do so. Why did this have to be inserted? This wasn't originally in the Act. Because many violent men had used the defence of provocation to have their offence reduced from murder to manslaughter in situations where they said they were so provoked by a partner who said they were leaving them that they had to kill her. And there's been a range of those, often things such as saying that they would leave and laughing, or saying they would leave and have a new partner was considered sufficient for a man to actually reasonably have lost self-control and have killed his partner. Please note that the provocation on use of non-lethal force does not have this type of limit in it. In theory, a person could still argue, if they use non-lethal force against a partner, that the partner had provoked them by saying they would change or end the relationship in some way. So that's still a little bit scary. As I said, there are also the use of diminished responsibility defences structured around issues of battered women's syndrome. You may look at those a bit in evidence when you look at some of the issues around evidence of criminal responsibility and mental state. However, now somewhat overtaken by the addition of section 304B to the criminal code. 304B acts to reduce murder to manslaughter where there's been a killing for preservation in an abusive domestic relationship. Here you must find that there was an abusive domestic relationship in using the same definitions of domestic relationship as in the protection order legislation. That means it includes not only intimate partner violence, but also certain types of family relationship and others. The abusive history also fits the definition in that legislation. If there has been a history of abuse in the domestic relationship, and where one party, the deceased, has threatened or used violence towards the perpetrator, in a situation where the perpetrator then believed that they would be subject to being killed or having grievous bodily harm done to them, then the perpetrator can use Section 304B. And where they have killed their abusive ex-partner, it does not require the level of immediacy of provocation or self-defense, which, as you know, are based somewhat around the pub brawl idea of violence and have been critiqued as being a particularly masculine type of defense, in that they reflect men's experience of violence between two relatively equal participants, not always, but relatively equal, that happens of a sudden and where a person has the capacity to respond of a sudden. 304B actually acknowledges that for in a domestic violence situation, there is not always a situation of equality, and that sometimes people will act to harm or kill an abusive partner where they are incapacitated. And a range of the cases have occurred where people were sleeping or drugged at the time. In addition, there's also a new offence in the code, the strangulation offence, which actually increases penalties for choking, suffocation or strangulation in a domestic setting. It was added in 2016 as a response to the fact that choking, suffocation or strangulation is actually a really high indicator that for future domestic homicide. It is one of the few forms of abuse which has a very clear link to later homicidal acts by an abusive partner. And so it's actually seen as a more severe offence than other types of abuse and other types of assault. There are a couple of other offences which might be of interest to you and which can relate to family violence, which include Section 323A. Female genital mutilation is not allowed under our criminal code. Interestingly, it does not ban plastic surgery of the genitalia for aesthetic reasons, but it does for certain types of cultural reasons. And it's also an offence to remove a child from the state of Queensland for the purpose of accessing FGM and for that child. These were added to the code in 2000. You can see that they're clearly targeted at certain cultural groups, and they're clearly intended to protect, in particular, young women from genital mutilation. So they can come into play in situations where there is a requirement that a young person be mutilated before a marriage, etc. So, and there have been some prosecutions under those sections. So that's it, our criminal code and domestic violence, as you can see, relatively slim and offers some protections for persons who kill effectively in self-defense, though our understanding of self-defense is very much based on the context of a fight rather than the context of fear of future and ongoing domestic violence, such as in the Kina case, where Kina was terrified for what would happen in the morning when her partner, who had threatened her with death and who had threatened to sexually assault her niece in the morning, would wake up, and she thought her only choice to protect her niece from a horrible level of sexual abuse was to kill her partner. and others who are in a similar situation often fear what will happen at some point in the future. And 304B allows for an understanding of that in a way that the previously very masculinized understanding of defences under our criminal code did not.